of making things right. Thank you.
Sir Jeremy Wright.
Thank you very much, Madam Deputy Speaker. It's a privilege to follow the honourable gentleman for Crawley. I admire his principles and his persistence in his advocacy for his Chagosian constituents, and I know he would recognise that his predecessor did the same. Madam Deputy Speaker, there is no dispute, I think, that Diego Garcia is crucial to the UK security and that of its allies. That is not something we are arguing about. And I do not think, though I'll be corrected if I'm wrong, that it is the government's position that in terms of the day-to-day practicalities of operating the Diego Garcia base, this new arrangement, whereby we no longer have sovereignty over Diego Garcia, but we will continue to administer it, at least for 99 years, do not think it's the government position that that new arrangement is better than what we have now, but rather that it is a more secure arrangement because of what has been described as the legal uncertainty surrounding our sovereignty over it. I see the Minister nodding, and I'm grateful for that.
Will you give way at that point?
I will give way.
I'm very grateful to the member for giving way and using his legal background. It is more secure legally until 99 years, but actually more definitively at that 99-year point, if the Mauritians decide not to have a base there, categorically that is their decision. So therefore, by proxy, it's actually more unsafe just in 100 years' time.
Well, I understand the point that my honourable friend makes, and I think it's reinforced by the point that our right honourable friend made in reading from the agreement as to how any disputes are resolved. But I want to focus, if I may, on the position now and the legal justification the government has already deployed for the arrangement it seeks to make. He's right, there will be further problems down the road, but I think there are problems already. It seems to me that if the position the government takes is as I've set it out, and as the Minister accepts that it is, that must be right, because it would be surely difficult to argue that were it not for that legal uncertainty, renting Diego Garcia back from someone else would be better than owning it from a security point of view. So for the government to persuade us in this House, and indeed the country as a whole, that this is a good deal for Britain, everything turns, does it not, on this question of legal uncertainty, which ministers have often referred to as the reason why this treaty and therefore this bill are necessary. Now, Madam Deputy Speaker, having spent 4 years as Attorney General, I am quite familiar with legal uncertainty. There is a lot of it about in government. It is, I'm afraid, invariably the case that whenever a decision is made in government, someone disagrees with it. And some of those who disagree will be prepared to go to a court and challenge the validity of that decision. And until the court, sometimes until the Supreme Court, has resolved the matter, there can fairly be said to be legal uncertainty about it. Legal uncertainty hangs around government like the clouds, and it cannot, Madam Deputy Speaker, be allowed to paralyse a government, nor should that sort of atmospheric legal uncertainty be the only cause of a decision as significant as that which this government is now making to give up sovereignty over a vital military facility. So there mustn't there be something more substantive, something more tangible to the legal uncertainty that ministers have referred to than that. And many of us, Madam Deputy Speaker, have tried to find out what exactly that is, but with, I'm afraid, very limited success. And given that the legal uncertainty which is being talked about here constitutes the entirety, as far as I can tell, of the burning platform which the government relies upon to justify this bill and this treaty, surely before this House approves either of them, it really must be given a proper and clear explanation of precisely what legal jeopardy the government is acting in response to. And in pursuit of that, it's worth having a look back at the explanations that ministers have given so far. So let's start with the former Foreign Secretary, now of course the Deputy Prime Minister, who made a statement on the British Indian Ocean Territory negotiations on the 7th of October last year. He told this House that the issue of contested sovereignty over Diego Garcia was becoming more acute, and at column 45 of Hansard from that day, and I quote, "A binding judgment against the UK seemed inevitable." So many of us have been asking where that inevitable binding judgment might come from. The only court which had by then been mentioned was the International Court of Justice, the ICJ, which had issued an advisory opinion on sovereignty over the Chagos Islands and Diego Garcia. Indeed, on this subject, it could only have been an advisory decision, because the UK accepted the compulsory jurisdiction of the ICJ by declarations dated the 22nd of February 2017. I was the Attorney General at the time. And those decisions, those declarations, made it clear that the UK did not, however, accept that compulsory jurisdiction in relation to, and again I quote, any dispute with the government of any other country which is or has been a member of the Commonwealth. Now that involves and includes Mauritius, of course. So any dispute with Mauritius before the ICJ could not result in a binding judgment against the United Kingdom. Now this point has been put to ministers, and as far as I know, they have not dissented from that analysis. So, if the ICJ could not make the binding judgment that the former Foreign Secretary told us was inevitable, which other court might? And on this again, we have not, I'm afraid, had clarity. On the 13th of November last year, the Foreign Office Minister of State, the Honourable Member for Cardiff South and Penarth, who I see has the misfortune to have to defend this position once again today, answered an urgent question on the Chagos Islands. And what he said was this: international courts were reaching judgments on the basis that Mauritius had sovereignty over the Chagos archipelago. He did not at that point say which courts, but I've done some digging, Madam Deputy Speaker, and I think I'm supported in this assumption by what the Minister who opened the debate also said today. I think he may have been referring to a determination made by the Special Chamber of the International Tribunal of the Law of the Sea in January of 2021, when considering a dispute between Mauritius and the Maldives. Now, tragically, Madam Deputy Speaker, I don't have time to go into the fascinating detail of that case, but in essence, it was a dispute about the delimitation of maritime territory between those two states. The Maldives argued that the Special Chamber could not determine the case in question because there was an ongoing dispute about the sovereignty of the Chagos Islands between, of course, Mauritius and the UK. The Special Chamber, though, decided that it could treat Mauritius as the coastal state in the dispute before it because of the ICJ's advisory opinion on the matter, which it said had legal effect. Well, if that ITLOS case is what the government is relying on, I think there are a few problems. First of all, the UK was not a party to that case. And secondly, the ITLOS chamber was seemingly basing its decision on that of the ICJ, which, as I've already indicated, could not make a binding ruling on the matter. Now, Madam Deputy Speaker, I'm not expecting the House, much less the government, to accept my opinion on this. But at the very least, it seems to me that the UK would have the basis of a decent legal argument here. And it does not seem to me that this ITLOS decision demonstrates that there was no further hope for UK claims of sovereignty over Diego Garcia. So, Madam Deputy Speaker, after a bit more prodding, the government's argument moves on and introduces the issue of access to the electromagnetic spectrum. And on the 5th of February this year, the Minister, again, the Honourable Gentleman who's in his place, answers yet another urgent question on the subject. I'll give way to my right honourable friend.
Before he moves on to the spectrum, can I bring him back to UNCLOS? Because as I understand it, we had specific exemptions across all of these areas. I think Articles 298B and 298C gave us specific exemptions against UNCLOS judgments that are relevant to the UK in disputes concerning military activity by government vessels and aircraft in non-commercial service and disputes concerning law enforcement activities for the UK in these areas. So on that as well, their argument on UNCLOS falls, surely.
Well, I'm going to give my right honourable friend one of the lawyer's favourite answers to any question, which is it's complicated. But here's the point. The only legal analysis being offered here, the only explanation, comes from this side of the House. The government isn't giving us any. If my right honourable friend is wrong in what he says, we really need to hear from the Minister why. And we are not hearing from the Minister why, and that is what troubles me. Of course I give way.
And if he is willing to give explanations, please could he explain why your party chose to start the engagement and at no point explained the rationale for doing so?
Yes, I'm coming to that. If the honourable gentleman would be patient, I promise I will come to that. But I just want to deal I hope in a logical order with what ministers have themselves said about the justifications for their actions. And as I said, on the 5th of February, the Minister answered another urgent question, and in answer to my plea to give us more clarity on exactly what legal basis the government was acting on, he said, and I'm looking at column 760, the following: we currently have unrestricted and sole access to the electromagnetic spectrum, which is used to communicate with satellites and which is guaranteed and governed by the International Telecommunications Union, a United Nations body based in Geneva. If we lose it, we can still communicate, but so can others. I understand the point that the honourable gentleman was making. But he didn't explain how that issue might lead to a binding court ruling against the UK, and he didn't even take a second opportunity to do so when asked about it again by my honourable friend for Spelthorne, which those interested can find at column 762. Luckily, though, my right honourable friend, the Shadow Foreign Secretary, called a debate on this subject in opposition time on the 26th of February, which was answered by the then Minister of State, the Right Honourable Member for Oxford East. She repeated at column 874 on that day that, and I quote, without a negotiated deal with Mauritius, it would pursue its legal campaign. Then she said that would lead to an inevitable legally binding judgment. She was then interrupted, but went on to say, and again I quote, in that kind of situation, presumably the kind of situation she was referring to was the delivery of a binding judgment against the UK, in that kind of situation we would unfortunately see international organisations following that determination, such as the International Telecommunications Union. So, Madam Deputy Speaker, if you put all these ministerial utterances together, we're going round in circles. Yes, exactly. The government says it has to act because of the inevitability of a binding court judgment against the UK. It mentions the ICJ, but the ICJ can't make a binding judgment against the UK on this. It hints at it-loss cases, but they refer to ICJ decisions. The government then says it's worried about the actions of the International Telecommunications Union, but when pressed, it seems to mean actions which would follow a binding court judgment. So we're back to square one.
Can you allow me, just briefly?
Of course.
Is it not the case, as he is a former Attorney General, that the ITU treaty, to which we and others are a party, states very specifically that the ITU has no authority over the allocation of military spectrum, i.e. military communications? So it's very clear the ITU has no leverage legally at all over Diego Garcia.
Well, my right honourable friend makes an important point, and I know he's made it before. And again, I repeat the point I made earlier. We are simply not getting from the government an adequate rebuttal of these points. And we need to have it, because if the government has a good answer to what he has said, to what my honourable friend for Bosworth has said, then it really is the moment, isn't it, at second reading of this bill, for the government to deliver that explanation. And we are all still waiting. I give way to my right honourable friend.
I'm very grateful to my right honourable friend. My honourable friend on the front bench is right, but actually the existing position goes even further. Is my right friend aware of the answer from the government given in February in this year, which says individual countries, not the ITU, make their own sovereign spectrum assignments in accordance with the radio regulations? The ITU has no legal authority over these assignments, regardless of the country's civilian or military classification of spectrum.
Well, I'm extremely grateful to my right honourable friend, because I should refine my argument then. It isn't just that the government isn't answering the questions, it's when they do answer the questions, they undermine their own argument. It's worse than we thought. But the point here is that not just that we are not getting clarity from the government about what the legal judgment that they themselves have relied upon as the almost entire basis for their actions actually would be, but that this really matters. The government owes us a proper explanation. Now, I am prepared to concede, I hope the Minister will accept I'm a fair-minded person, I am prepared to concede there may indeed be a persuasive argument the government can make as to which court, under which circumstances, will deliver the kind of judgment that makes this action inevitable and necessary. But I really have waited a long time to hear it, and I'm still waiting. And I do hope that the Minister, when he stands up to sum up this debate in one moment, will give us that answer, because the House of Commons deserves to hear it. I give way one more time.
This is fundamental to the whole argument. We've pressed the government for months to tell us what was the legal threat to the islands. And in his opening speech, the Minister said it was UNCLOS. That was the justification they've given us. But does he agree with me that we have a general opt-out and two specific opt-outs under Article 298B of the UN Convention on the Law of the Sea, including, and I quote, disputes concerning military activities? So we have an opt-out from UNCLOS. So the government's whole case is spurious. £35 billion worth of spurious, isn't it?
It's certainly very expensive. I know lawyers who would charge big fees, but none of them would come close to that. My right honourable friend makes his point, and I think, again, the Minister has another opportunity when he speaks. It isn't good enough, I'm afraid, for hints and oblique references to be made. We are owed a clear explanation. This is a fundamental decision in terms of defence and security, in financial terms, as my right honourable friend has just said. We deserve to know. Now, if the Minister is going to say to us that describing all of this in detail is the sort of confidential and sensitive information that the whole House can't hear, well, I have good news for him. That's what the Intelligence and Security Committee of Parliament is for. And I have the honour to be a member of that committee. And it is, if I may say in passing, Madam Deputy Speaker, perhaps regrettable that the government didn't choose to explain itself and make its case to us before it brought this bill to the House. But it did not. I give way to my fellow committee member.
I'm extremely grateful to the former Attorney General for giving way. And he's right that this matter could have been brought to our committee, but I think he'd also want to confirm it still could. So even if at this late juncture an overture were made to our committee, clearly it would have to be discussed at committee, but it would be perfectly possible for the government to set out in those terms the advice they received, which legitimises the position they've taken.
Yes, I think my right honourable friend makes a good point, and although all our hearings are held within closed doors, he's right that until that happens, our door is open. So there is an opportunity for the Minister, if he wishes to take it, to make that proposal. But I want to come back to the point that the honourable gentleman made on intervention, because his rejoinder, the rejoinders of his colleagues, the rejoinders of ministers have always been the same throughout this debate, which is they say, well, the last government began negotiations on this, so clearly the last government accepts the same logic that we accept. Well, Madam Deputy Speaker, that simply won't do. As ministers have been very keen to point out, as indeed have backbenchers behind them, the last government had 11 rounds of negotiation on this question. If they had chosen to do the deal that this government has done, they had ample opportunity to do it. And they did not. And that can only be because they did not believe it was the right deal to do. Now, this government is undoubtedly enthusiastic about getting swift resolution of disputes. They apply the same principles to labour disputes, it seems. But I have to say to the government that settling a negotiation fast is really very easy if you give the person you're negotiating with everything they want. What Mauritius wanted out of this negotiation was sovereignty over the entire Chagos archipelago, and that is what this government has given them. So we really can't award any points, I'm afraid, for the fact that this government has managed to resolve this issue more swiftly. The fact that the government that some of us on this side were part of did not resolve it that quickly is because perhaps they were not prepared to give ground on that particular issue. So, Madam Deputy Speaker, we do need an explanation as to why the government feels it's necessary to do this deal. We need an explanation on what precisely the legal jeopardy it faces is and what is its origin. And we need to know what is the binding legal judgment that it fears. And frankly, Madam Deputy Speaker, without those explanations, this House should not be asked to agree to this bill or this treaty.
Graham Downey.
Thank you very much,